thank you, Hannah. I don't think there is very much of an introduction necessary, really. We have, if all speakers keep to the time schedule, we still have a lot to fit into the 60 minutes plan. So I think we should get started. And I suggest that we do keep the order that you sent out, Hannah. Which means that we will first hear from Indran at Schöndelmore about recent decisions in Malaysia, and then from Kanako regarding the amendments of the Japanese design law recently. Myself, you're about the unitary patent and the UPC, which is actually now looking at if it is going to happen. And then Peter from Goodman's in Canada, about click wrap or click-through terms in electronic agreements, and last from Strat at Block Lord in the US about a US Supreme Court. So with that, I think Indran.
Okay, thanks for. I'm just going to share the screen if that works. Otherwise, I'm just going to speak based on whatever notes that I have. Let me just share screen. Okay.
Yeah, we see it.
Okay, let's see what do I do now? How do I put it into a slideshow? Okay. Okay, I essentially have two cases to talk about. One is a patent case and one is a trademark case. Now, if I have insufficient time, I'm just going to concentrate on the patent case alone because there are plenty of issues in the patent case. Now, both these cases, the patent case and the trademark case, actually went all the way up to the highest court in Malaysia, which is extremely rare. I actually had the honor of appearing in both cases. And to a certain extent, they have altered the laws in relation to both the subject matters, trademark and patents as well. Now, in terms of rarity, IP cases rarely end up in our highest court. There are only 3 patent cases that actually went up to the highest court. And therefore, a decision of this nature is very, very significant. Insofar as trademark cases are concerned, in the history of Malaysian jurisprudence of the last 50, 60 years, probably about 10 cases have ended up in the highest court, which is called the Federal Court of Malaysia. Now, appeals to the Federal Court of Malaysia are only on points of law and points of law of national importance, so national and public importance. So let me just go through the slides. The first case is the case of Merck, Sharp and Dome against Hovid. Now, this related to a patent claim in relation to a pharmaceutical dose compound, not a compound claim, but rather a dose. And Merck filed an action for patent infringement, and the normal invalidity attacks, as is common in all patent cases, came up. Hovid challenged the patent on the ground of novelty, lack of novelty, that the invention was obvious, the person skilled in the art. And then they also challenged it on the basis that it was a method of treatment. And then they also challenged it on the ground of insufficient disclosure. Now, the patent had 22 claims, 1 independent claim, and 21 dependent claims. Now, at the point of time when this case came up to the High Court in 2014 and a decision in 2016, we had a very peculiar case, a peculiar decision from the Federal Court of Malaysia, which is the highest court at that time, only the second patent case at that particular time, which held that if an independent claim to a patent was declared to be invalid, all claims dependent on that independent claim would be declared invalid automatically without its validity being assessed separately. Now, this is a very peculiar decision, obviously not consistent with the position in all the jurisdictions around the world. So, obviously, quite a difficult decision. And as we all know, patent claims are drafted in a way where the dependent claim has a very wide scope. And then with the independent claim is a very wide scope, and the claims that are dependent upon it usually with a narrower scope, which means it was harder to challenge dependent claims, although the independent claims offered a wider range of protection. So at that particular time, 1 independent claim, 21 dependent claims to Merck. Now, what happened in the High Court was that while the court held that Hovid had actually manufactured a drug and a dosage range which came within the claims of Merck's patent, and there were about 5 claims that were in issue. the court also held that independent claim number 1 was obvious to person skilled in the art, therefore invalidating independent claim 1. And as a result of the previous federal court decision and the case of SKB Shutters, which is mentioned in the slide, automatically held that all dependent claims collapsed as well, without it needed to be assessed separately. And therefore, by reason of the invalidity of the independent claim, the entire and the dependent claims, of course, Merck didn't have a patent to rely on for the purpose of infringement, and infringement collapsed as well. Now, what happened is the case went up to the Court of Appeal. The Court of Appeal, again bound by the federal court decision, had to follow exactly what the federal court had said, and also overturned Merck's appeal. So Merck, because it was a question of law of public importance, and the fact that this was a matter that affected 150,000 patents at the time in Malaysia, the matter was, leave was granted to the federal court, and the matter went up on substantive appeal upon leave being granted. And the issue that the plaintiff Merck asked the federal court to consider is, notwithstanding a previous decision of the federal court itself, whether dependent claims would collapse automatically on the finding of invalidity of an independent claim. And when the court decided, based on that, the court decided that that will not be the case, although what they went on to find was a peculiar way, which is only found in Malaysia, obviously, to classify the different types of claims. They held that there are two types of dependent claim. Type 1 dependent claims, and this is exactly how it's described by the federal court, is a dependent claim which are subsets of the independent claim, in the essence that the dependent claim has all the elements of the independent claim, but actually with a limitation. So that was the type 1 claim. And then you had type 2 claims, where the dependent claim had additions to the independent, means have all the features of the independent claim with addition. So one would be a dependent claim with all the features of the independent claim with limitations. And secondly would be type 2 claims, which was claims which had all the features of the independent claim with additional features. So those are the distinctions. And what the federal court held was that in the case of type 1 claims, type 1 dependent claims, the dependent claim would fall automatically upon the finding of invalidity of the independent claim. And what the court said is, since the High Court, on first instance, did not look at the validity of the dependent claims 2 to 22, they remitted the matter back to the High Court. So the case came back to the High Court, and Hovitt, the defendant in the case, took the position that the claims relied upon by the plaintiff Merck were all type 1 claims, and therefore it had to be invalidated. And remember, the claim in this case was a dosage range. Claim 1 had a claim which said a dose range of between 10 milligrams to 140 milligrams. The court, in finding claim 1 to be invalid on the basis that 20 milligrams was obvious, but obviously 20 milligrams doesn't include 140 milligrams. So what was argued by Merck in the High Court, clarifying the position of the Court of Appeal, that a type 1 dependent claim would only collapse automatically on the finding of invalidity of the independent claim if the entire range of the independent claim was held to be invalid. In other words, the entire range between 10 milligram and 140 milligram had to be found to be obvious before an automatic finding could be reached. So therefore, there was a clarification on how the courts determine independent type 1 dependent claim. So in that context, the court said that while Merck's claims in the context of the infringement actions were type 1 claims, it did not automatically collapse because the independent claim was not, the entire range of the independent claim was not held to be invalid. The other issue that was determined by the High Court in the context of this case is the determination of the person's skill in the art, or generally described as the posita. The court in this case held that the posita, in this case, the notional person skill in the art, would be a combination of experts and not a single expert. And in this case, it included a gastroenterologist and an endocrinologist. And therefore, since the expert by the defendant Hovitt only included an endocrinologist, they had not discharged the burden of proving by bringing the notional person skill in the art to show that the invention was obvious at the priority date of the patent. So on that basis, the High Court found for Merck, and therefore clarifying how type 1 dependent claims and type 2 dependent claims are assessed. Now, again, this is a fairly new concept, only found in Malaysia, but then the clarification of the High Court really added context to how the federal court had decided on the status of independent and dependent claims. So that was one patent case. I still think I have got a little bit of time. I'm going to go very quickly on another case that ended up again in our federal court, and it's again another peculiar decision because of how the Court of Appeal had found on this case. Now, this is a very simple enough case, a trademark infringement case. On one hand was the plaintiff's trademark, it was biscuits. The plaintiff's trademark was Lexus, and the defendant's trademark was Lex. And I think most trademark practitioners will understand that in cases like this, where you have on one hand Lexus and the other hand Lex, decisions are often arrived almost on the flip of a coin. You'll have some judges who can find these trademarks to be confusingly similar, and similarly you'll have some judges who would not find it. The only issue that often is in cases such as this is whether the judge has applied the correct principles. Now, what happened is when the evidence was led, the court came to the finding based on the evidence led that these trademarks were confusingly similar, thereby finding in favor of the plaintiff. And in deciding on these things, the principles that they applied was you look at the trademark and the get-up in totality, identify the essential elements, and then apply what is described as the imperfect recollection test, which means the marks should not be compared side by side, but in the absence of each other. And based on all this, and looking at consumer perception and also how the products actually sold, the trade channels, the court came to the finding that the trademark Lexus was confusingly similar, or Lex was confusingly similar to Lexus, as well as the fact that the get-ups employed on the packaging was also similar, therefore finding both trademark infringement and passing off. Now, I'll go straight to the Court of Appeals finding. Now, this is very peculiar. The defendant obviously appealed, and on the basis that the court applied the wrong test, applied the wrong evidence, and applying the law wrongly on the evidence presented, and which is a very fairly reasonable position to take. But instead of the court looking at the arguments of both parties, and of course we argued that applying all those principles, the marks are similar. Now, instead of the court considering those, and usually on appeal, the Court of Appeal will only overturn the decision of the High Court if it's obviously wrong. And instead of doing that, the Court of Appeal came up with some rather peculiar new principles, which would have an effect had it not been overturned by the federal court on future cases, because on the basis of the standing of the courts, decisions of the Court of Appeal bind all courts below, including the High Court. Now, what the Court of Appeal said is, trademark rights are meant to create monopolistic rights, which is a very peculiar position to take given the exclusivity that is often granted to all IP right holders. So that is the first position they take. And then they said that parties should look at ways of coexisting with suitable variations to the trademark, almost suggesting that a plaintiff trademark owner should consider varying their trademark to coexist with the defendant who came later, which was an extremely peculiar position to take, extremely strange. Of course, they didn't say who needed to vary their trademark, but variation can only take place in relation to a registered trademark. The plaintiff's trademark was a registered trademark, and the defendant's trademark was not registered. So by suggesting variations, they almost were suggesting that the plaintiff who came first in time should not claim monopolistic rights against a defendant who came later. And the way to settle the dispute is for the plaintiff to go and amend their registered trademark. Very peculiar position to take. Obviously, that could not stand. The matter went up on appeal to the federal court decision, through the federal court, and the federal court's decision was that the Court of Appeal should not have introduced new concepts, jurisprudential concepts to trademark law. It was not an issue of coexistence. Both parties could coexist in the trade and industry so long as they employed different trademarks. Asking the plaintiff to amend the trademark when they came first was a rather peculiar and inconsistent position to take with how trademarks are to feature in the course of trade and industry, and therefore reverting to what is generally recognized as the principles applicable to registered trademarks. So for a short while in Malaysia, we had a rather peculiar position, which would have meant that rights to a trademark would have been compromised by reason of this decision. But fortunately, this has been overturned, and normal business can therefore resume. I hope I have kept within my time. That would be all. And if there are any questions, I can take them now, or maybe I can just pass it on to the next speaker. Wait, let me just stop share. Okay.
Thank you very much, Indran. A good turnaround, I think, in the Supreme Court on the trademark case. That would have been a difficult type of practice to live with. I think we should probably go on to Kanoko, and if we have time at the end for questions, we should probably do them at that time. So, Kanako, are you ready to start presenting on the Japanese issue?
Yes. Nice to meet you. I'm Kanako Inoguchi, and I would like to introduce the amendment of the Design Act that came into effect on April 1st, 2020, 2 years ago, and current status. This amendment relates to the design of the interior and exterior of store. I'm sorry, I have not prepared any slide, but only prepared my own script. And I can show you the government material. Okay, I can share this one. Can you see? Okay, maybe.
Okay, it's fine.
Anyway, yes. My explanation is irrelevant to this pictures. Anyway, as for the protection of store design, there is the Lanham Act of the United States, which protects it as trade dress. Your country may have similar rights, maybe. Trade dress protects the total image or overall appearance of a business created by the combination of visual elements in the exterior and interior of a store. Such a total image has the same distinctiveness as a trademark. Trade dress can be registered as a trademark, and like a trademark, it can be protected by acquiring secondary meaning in the United States. In Japan, there is no such concept as trade dress, and there has been much debate over the past decade about how to protect store designs that have distinctiveness. There have been several cases in court where store designs were challenged as being imitated in violation of the Unfair Competition Prevention Act. In fact, there have been a judgment in which unfair competition has been recognized on the grounds that the store design have acquired distinctiveness as an indication of origin through continuous use. However, such judgment also does not recognize the protection of total image. In order to take into account the individual elements that create a distinctive appearance, the courts have also contrasted the components of the appearance. Store owners may consider the total image, apart from the individual components, to be another important point that they want to differentiate from other companies. Japan decided to protect store designs by the Design Act. The Design Act is a system to protect the originality of industrial designs like the Patent Act. It is also industrial property right and therefore cannot be registered unless it is novel and non-obviousness. As of February 1st, the number of registration for graphics, buildings, and interiors in Japan was 1,255. The number of applications is 7,148. It is believed that many of these have not yet been examined. There are still no court cases based on new design rights. I should explain the picture on before your screens. This is the first registration of this new design. This is the store outlook building of Uniqlo. I'm not sure. Uniqlo maybe has stores in your countries, but I'm not sure how to pronounce Uniqlo or any other store name. At least this is building design. And the next one is station design. This is new design, registered design. And the third one is interior of the store. This is a very famous bookstore in Japan. Very special design they have. Okay, I should continue. One of the problems with the protection of the store designs under the Design Act is that it does not focus on the distinctiveness of the design. Even if a store design that is not inherently distinctive acquires a secondary meaning through continuous use, it will not be protected by the Design Act. As a result of the fact that protection under the Design Act does not focus on distinctiveness, it cannot fulfill the purpose of brand protection like a trademark. Under the Design Act, protection is quite limited. In the case of design infringement, the design must be similar, but due to the nature of design protection, similarity is required more strictly than in the case of trademark. In addition, there is no concept of derivative work as in the case of copyright. Therefore, there is a limit to the protection of store designs under the Design Act. If your client asks you to help them protect their store design, you have a choice between protection under the Design Act or the Unfair Competition Prevention Act. There are advantages and disadvantages to both types of protection. That's all. Thank you very much.
Well, thank you very much. Interesting concept. I must say I'm not familiar with any conceptual design of stores being protected, at least not in Sweden. I don't think in the EU. It's interesting thought. Thank you very much. Thank you.
Thank you.
Okay, that means it's my turn, I guess. And I will try to start sharing my screen. There. Can you see it now?
Yes.
Very good.
We can. Yes, good.
Very good.
But it's not in presentation mode. We
Let's
can see all of that. We can see
this. Like that?
So if you right click, you should be able to do slideshow. Or if you select the little icon down on the bottom.
Icon down at the bottom.
So at the very bottom of your screen, you see there's 4 icons in a row before you can, I think that's, no. Yes, down there where your mouse was, it's the one all the way over to the right. Yep, that's it.
Okay.
That is how I usually get into slideshow mode, and it's not working for me.
Oh, well,
but why don't
you see the
we can
pictures
see
anyway, so it's good.
Yes.
Okay. Per Lidman from Cederwall, Sweden. I'm going to talk to you about the European patent system, which is undergoing some major changes that likely will have quite a significant impact. And this is after years of legal and also political problems. The Unitary Patent and the Unified Patent Court, both often actually referred to as the UPC, could, or that is, some say should, or but I still say could soon see the light of day, late 2022 or early 2023. The current European patent system, a European patent is granted by the European Patent Office or the EPO, but such a granted patent is then divided into a number of independent national patents. That is by sort of designating countries in which the patent holder opts to validate his patent. And the result then is several national patent rights, separate rights, and enforcement and revocation thus has to be initiated on a country-by-country basis in the national courts. Then the new unitary patent will be existing in parallel to the now existing European patents as a new pan-European patent right. And it's quite realistically now expected to come into force in late 2022 or early 2023. As with the current patents, this will be obtained through an application to the EPO and prosecuting that patent with the EPO until it's granted. But however, and unlike the current European patent, which has effect only in those countries in which it is validated, a unitary patent will provide a single patent right with unitary effect across multiple European countries. We see at the bottom of the picture in the white text the countries currently included, and I won't name them all. But countries that are parties to the current European Patent Convention, but that are not EU member states, such as Norway, Switzerland, and more recently the UK, they are not participating in the UPC and will not be covered by the unitary patent. Neither will it be possible for existing patent rights in these countries to be tested under the UPC system. Patent protection for these countries must continue to be sought either nationally or via traditional European patent validations and the current systems. So for some time, unitary patents will not replace the existing European patents, but rather will exist in parallel. But hence, after that the unitary patent has come into force, and once a European patent application is allowed by the EPO, patent holders will then have the option of either validating their European patent in select countries according to the current system, or convert their European patent into a unitary patent with the unitary coverage, as we mentioned. Or actually three, opting for a hybrid version of this, in which the European patent is converted into a unitary patent, but also validated in select countries that are not covered by the unitary patent. We haven't seen this in practice yet, so everyone is a little bit curious about how this will work. But I could mention that the yearly cost of renewing a unitary patent is expected to be roughly the same cost as renewing 6 national patents. So patent holders that regularly or normally validate their European patents in more than 6 countries may actually see significant cost savings through the system with the unitary patent. With this new system, we will also see the introduction of a new centralized patent court, the Unified Patent Court, or UPC. This will provide a one-stop shop for infringement and validity proceedings relating to unitary patents. And likewise, unitary patents will only be enforceable by or through the UPC. And decisions by the UPC will have unilateral effect in all countries that are parties to the UPC. And this is perhaps the biggest effect or change that we see. And not surprisingly, unitary patent can only be challenged in the UPC. And if found invalid, a unitary patent will be revoked in its entirety. That is, patent protection will be lost in all countries covered by such unitary patent by one court decision. But in addition to this, and to complicate things a little bit, holders of existing European patents will also have the option of litigating the national validations of such patents before the EUPC. Since decisions by the UPC will have effect in all countries that are parties to the UPC, a patent holder may simultaneously enforce the national validations of their European patent via the UPC and obtain an injunction covering all territories associated with the nationally validated patent. So it's the UPC, the court sort of allows a new procedure also for existing European patents. From the opposite perspective, a potential infringer may apply to the UPC to revoke all national validations of a European patent under the UPC's jurisdictions, or make a claim for declaratory non-infringement. So it works both ways. So, well, when is this happening then? Well, the Brexit slowed it down a little bit, and there has been some other challenges legally to the ratification. But currently, the forecast is, as I already mentioned, late 2022 or early 2023. Then you can ask yourself, do I have to participate in this system? Well, eventually, yes, but not initially. Because during a transitional period of at least 7 years after the coming into force of the UPC, owners of existing European patents will have the option to opt out of the UPC jurisdiction for any of their existing and future European patents and applications. The period for opting out is often referred to as the sunrise period. And this period is actually expected to commence prior to the entry into force of the UPC. That is sometime this year, but it's still, the precise timing is still a bit uncertain. We don't know, simply. And what happens then to European patents that are opted out? Well, they will remain in force as a number of separate individual national patents that can only be enforced and challenged in the national courts. On the other hand, those European patents that are not opted out will fall under the jurisdiction of both the national courts and the UPC once it comes into force. As I think I mentioned, this means that European patents that are not opted out might be litigated in the UPC, and theoretically, the national validations of a European patent that is not opted out during the sunrise period could, on the very first day of the UPC agreement coming into force, be subject to a central revocation action before the UPC, and ultimately invalidated for all countries it covers. So should I then opt out? Well, this is an important question, and the answer will depend on many factors. Some I have already mentioned, but in addition, there is a feeling, well, generally, I believe, that the UPC system confers a degree of uncertainty. No one really knows how the UPC will function in practice, and what existing court practice from different European jurisdictions will be adopted by the UPC. So for the time being, many say that it's wiser to adopt a better safe than sorry approach and opt out, especially in relation to patents of high value, not to risk them in being subject to decentralized revocation possibilities. And also there might be costs associated with these opt-out applications. And if you're a holder of many patents, those costs can actually be quite significant. That's another consideration that you need to make. And well, some people who argue for opting out also state as an important fact that the European patent which has been opted out may be opted in again by withdrawing the opt-out. And that is how the system is supposed to work. And this is provided that the litigation at the time of the withdrawal has not been initiated in any national court. Then you cannot sort of opt in again. So that is an argument. Just because you opt out, you're not excluded from the UPC and its benefit of wide-ranging jurisdictions. You can withdraw that opt-out later. And the most recent development is that the UPC agreement as such entered into force on 19 January, now 2022. And that means that the Unified Patent Court is actually introduced as an international organization. And the administrative committee has been inaugurated, replacing the preparatory committee. And well, perhaps more of interest to us Swedes than anyone else, it's a Swedish person, Alexander Ramsey, who has been elected chairman of this advisory committee, and with German deputy chairman Johannes Karche. And there is also now an advisory committee appointed, which will start interviewing judges, and that is presumed to happen now in March 2022. And hopefully they will be able to appoint these judges later during the year, forming the different divisions of the UPC. And as of the meeting of 22nd February, quite recently, as you see on the screen, a number of member states officially confirmed their intention of setting up local regional division of the UPC. And you can see the country abbreviations there.
Per, can you move to that slide? Just click on the one that you're trying to show.
Okay.
We're not seeing it.
You're not seeing it? Oh.
We see the main slide.
Okay.
Or you can send it to me, and I'm happy to circulate it after the meeting.
Yeah, I'll do that too. So sorry, on my screen it's showing, so I don't know why it's not. But anyway, the last part is not now. Just a few notes on what should I then do now if I have a client who is a patent holder or is about to apply for patents. Well, you should determine which patents should be opted out of the UPC, if any. And which should be left to then later opt in. And you should ask yourself, how important is this patent? And how large are the lifetime costs of maintaining this patent? So if the cost is an issue. You could also consider, if you have pending applications, to slow down the examination. There are various ways of doing that until the unitary patent comes into force. To have the option of converting it into a unitary patent. Or you can file divisionals to existing applications, which will then not be tried and granted before the UPC is in force, and you have the option of converting them into a unitary patent. But also from a different side, and this is the last point, you could consider for license agreements and such in relation to provisions in there, whether or not there is a need to revise or control these opt-in and out procedures when you're licensing your patent rights or licensing in. Thank you. I think I spoke a few minutes too much, and so I will stop there. Thank you. And with that, I think we are looking to Peter Ruby at Goodman's to speak about click-through terms of electronic agreements in Canada. Peter.
Thank you. So maybe we can turn to talk about a topic on the technology side of what this group addresses. We've done a fair bit of IP, and I tried to select for today something that's not uniquely Canadian. It's a small point, but perhaps interesting across many countries. And as this group will know, sometimes it's worth looking at a case not so much for the legal principle, but instead to see how judges apply the law to the facts in practice. And I'll tell you, I had a particular interest in this case because from time to time I sit as an arbitrator in international matters. And 2 years ago, I had a very similar situation, but of course it's completely confidential and I've never been able to talk about it. So it's good to have something that is public that makes essentially the same point. So many of you will know that the laws related to consumer protection for technology or internet contracts vary across jurisdictions and countries, sometimes with some commonalities, but a lot of it is quite varied. So, you know, there's always an issue of whether when a consumer clicks on an online contract to say they agree to it, when it's binding, when it's not, when they have to get a period where they can back away from the agreement and so on. And we also know that in the business to business context, parties are generally held to the agreements they make, whether it's online or not, whether they use a click-through approach or not, they're held to them. But at the end of last year, there was an interesting appellate case that fell between those two situations of traditional B2B as opposed to consumer contracts. And that's in a case where Microsoft Canada had fired a long-time employee, and the trial judge awarded this employee 24 months of pay. But the interesting question was what to do with unvested stock awards that the employee was holding at the time of his termination. And the company refused to vest the awards after he was terminated. And I pointed out, this came to me in an arbitration very often for senior employees. We're seeing more and more that these things are arbitrated, so they're dealt with not in public. So we don't often get these kinds of indications of how this works. So the stock award agreement, and there was an actual lengthy agreement that Microsoft Canada had put together. It provided, its key term was that unvested stock awards do not vest if the employment ends for any reason. So it's not just for just cause. The employment ends, you don't get the balance of your stock awards, period, end of story. And the trial judge in this case said that agreement was not enforceable because the employee did not receive notice of it. So let me go a little bit into the facts, and Strat, don't worry, I'm not going to take too long with this, and make sure you get some time as well. Each year for 16 years, this employee received an email notice of the stock award. The email announced the award and told him to click over to a website to get the details. And the details were described of the award were on the website. And also there was a click box where the employee could accept the stock award agreement. And each year for 16 years, this employee clicked on the button to say he accepted the award. We've all seen these kinds of situations before. But here at trial, the employee testified that he had never actually read the agreement, and it wasn't a mistake. He had consciously decided that he was not going to read the agreement. But despite that, the trial judge had said he had no actual notice of the termination clause. That is, that if his employment was terminated, he wouldn't get the stock awards that hadn't vested because he hadn't read it. Now, perhaps not terribly surprisingly, the Court of Appeal found that he was in this case trying to seek to take advantage of his own wrong and reverse the trial ruling, and found that the employee had enough notice because he'd been asked to read the agreement and click through to it and had clicked. But I'd suggest that really what's interesting here is there was actually a trial judge who sat through the whole process and heard the case and thought that even a non-consumer could escape being bound by an agreement by not reading it. And my final thought here as I watch the time is, I wonder what Microsoft could have done differently to not have this go through two levels of litigation. The email was quite clear, but nonetheless, it turned out not to be bulletproof. So if it turns out that there's some time at the end, I'm happy to discuss with this group on a prospective basis what we could tell our clients to use online agreements in these situations and not have to worry that you're going to end up in several years of litigation. As I said, I tried to get through this quickly, so thanks very much.
Well, thanks, Peter, for taking care of time for us others that exceeded ours. Strat.
Hello, everyone. So thanks to Amalia for asking me to give this talk. Unlike Peter, I've chosen a topic that is very specific to US law. And so to those of you who don't see much in the copyright realm in the US, you can just look at my wonderful background for a little while. So the Supreme Court of the US just came out with a decision in Unicolors versus H&M. It's kind of a minor decision. It doesn't really change much, but does clarify things moving forward. So basic facts. Unicolors owns copyright registration for a single work. However, the actual work consists of 32 images. So it really is a series of images. This is a problem in the US because a series of images, in order to obtain copyright protection, needs to be included in the same unit of publication, like a brochure, maybe a website. But Unicolors did not publish the images at the same time. And so boom, that's an error on the copyright registration. I think the real story is that Unicolors tried to save a few bucks, didn't think it was a big deal, and filed the applications. Or filed the application, got a registration. So when Unicolors tried to use that registration against H&M, H&M challenged it because it had inaccuracy. No one disputed that. The dispute comes along as to whether that inaccuracy will blow up the copyright registration. Unicolor said no, and H&M said yes. So looking to the language of the statute, the statute requires the inaccurate information was included on the application for the copyright registration with knowledge that it was inaccurate. And so that specifically says that the applicant needs to know, has some sort of a knowledge, whether it was inaccurate or not. The district court, so that's the US lower court, said, look, it's clear. It says that the applicant needed to have knowledge. No problems here. Applicant didn't know. This is not a viable challenge to the registration. The Ninth Circuit, I don't know if anyone's familiar here in the US, the Ninth Circuit, they want to do whatever they want to do. They decided that no, it is the error does doom the application or the registration, because the question of whether it's a single unit of publication or production is a question of law, not fact. Therefore, since it wasn't a factual mistake, the carve out, or the safe harbor, as the Supreme Court called it, doesn't apply. Okay, so it brings us to the Supreme Court. What did they find? Well, they looked to the statute, and the statute clearly says that the lack of either factual or legal knowledge can excuse an inaccuracy in a copyright registration. It's pretty clear. It was kind of weird that this had to go this far for the Supreme Court to say something that I found was pretty obvious by just reading the statute. But here we are. Basically the one of the good quotes was, nothing in the statutory languages suggests that the straightforward conclusion that is written in the statute should be any different simply because there was a mistake of law as opposed to a mistake of fact. So there you go. So why do we care? One of the big things when you have a client that's served with a copyright infringement lawsuit, the biggest thing to do is let's try to blow up that registration. That's really the big thing that we focus on. And why does that matter? Because in order to when you have a copyright registration, you cannot sue without it. And further, you cannot obtain statutory damages or attorney's fees for infringement that occurred prior to the registration. And so usually what happens when you get a demand letter or someone sues your client, you will say to your client, take down that infringing image right now. And so they do. And there you go. Boom. All infringements are over. And so therefore, if you blow up their registration, they don't get any statutory damages and they don't get any attorney's fees. And it really shifts the negotiating position, and it allows you to get out of it somewhat easily if you're in that position. So here we are. We have the Supreme Court saying that it's going to be a little harder to challenge registrations. I don't really think this matters that much in the grand scheme of things, because the decision doesn't change the law. If there is a major problem with the registration, then it still will be challengeable. So ownership, or whether it's a work made for hire, whether there's a proper assignment, all those things can be challenged. These are just kind of the immaterial errors that occur, and they do sometimes occur. I think that there's some publications that talk about how applicants are going to go at it without attorneys, or they're going to they're given more free reign, and I think that's fine. It will happen probably, but in the grand scheme of it all, this decision clarifies things. It kind of smacks the Ninth Circuit down a bit, because who knows where they came up with their distinction between factual and legal. And actually, I haven't read the cases, so don't ask me. But I don't know. That's my 8-minute spiel. Thank you. Let me know if you have questions.
Well, thank you, Strat. I think we'll just open up for questions from and to anybody, really. If there's someone who has a question, just unmute and speak up and tell us who you're directing your question to.
Hi, Indran here. I actually have a question for Kanako on the registration of the interior and exterior of a store, particularly in relation to the law in Japan. In Malaysia, to qualify for design protection, it is basically shapes, configuration, pattern, or ornament applied through an article, through an industrial process. So there is a requirement for the article or the design to be applied through an industrial process. Is there such a requirement in Japan? And if it is, how do they apply the features of shape, configuration, pattern, and ornament to an exterior or interior of a building through an industrial process?
Yes, design act is similar to patent act, and I think that procedure is almost same. For example, the store design, if you want to register store design, you have to prepare the application, and you have to and the design should be novel and non-obviousness. And I think almost similar. Maybe your system is similar. I think Japanese Design Act is similar to Japanese Patent Act. Maybe your country is the same thing, same system, but absolutely different from US system. I think. Is that okay?
Well, thank you, Kanako. I hope you got your question answered, Indra. Anyone else with a question to some of the speakers?
Hello, this is Marek. Maybe just one quick comment to Indra. Thank you very much also for your presentation. It's actually still right now a very vivid and valid point in Poland as regards the case law concerning scope of protection of dependent patent claims. So it was good to hear such a progress in your country. So thank you for the presentation.
Thanks.
Well, then I will pose a question, not to any of the speakers really, but to the audience. Just reactions from you all. Is this a format for a meeting with these sort of multitude of short presentations that is interesting to also do in the future? Is this a good format, do you think? Or should we have more lengthy presentations on fewer topics? If anyone has a point of view on that.
I think Damaso from Argentina, I think is a very good format, very dynamic. Perhaps I would only allow to have 3 presentations because it's a lot. 4 or 5 is, in my view, is a lot. And then allowing more interaction and Q&A session. But it's fantastic. It was very good today.
I actually agree with that, Damaso. I think having short updates, 8-10 minutes, actually a good idea, but maybe with longer interactive question and answer session. And in a way, we are a little bit more focused. I'm concerned sometimes if we have too many presentations, we forget some of the questions that we want to ask, as new topics come in. Memory as progresses is a problem.
That is a good point. Thank you. And I think the ambition was actually initially to have one speaker for each region. That is 3 presenters. But then we got more interesting topics lined up, and we sort of tried to squeeze them all in. But point taken. I think that is my opinion too. We should the format as such is good. But we should probably limit this to the 3 or a maximum of 4 speakers for an hour, because otherwise it doesn't allow for the exchange of questions and comments in the same way.
And Per, we do have somebody has their hand raised, and I don't want to mispronounce your name from Taylor Vessing.
Yeah, it's Wiebke. Hi.
Wiebke.
Well, thank you all very much for the interesting presentations. I was just wondering if possibly we could focus a bit more on broad topics. So, I mean, for example, I'm not a patent lawyer. So, of course, it's kind of interesting to hear things, but I feel that some of the information is kind of lost on me because I'm really not a specialist in this field. So I was just wondering if it might be more beneficial if we had kind of maybe more patent topics or more trademark topics or more design topics kind of bundled. But I mean, I know that this would kind of diminish the variety of the topics, but maybe would raise the level of potential debate because people would be more knowledgeable in their field of specialization. But I see that you can, it's kind of, you may choose to have a completely different way around.
I didn't mean to interrupt you, Pierre, but I have a viewpoint on that.
Let's go on, Al.
I was going to say, I actually think that with this, I agree completely about the concept of the shorter format. And at least for me, with the shorter format, I kind of enjoy hearing a presentation on things that I don't do every day. I agree with Victor that when you have to sit through those on longer performances, it doesn't seem like sometimes a productive use of time. But in this short form, for me, I find it fairly useful. The other potential suggestion that I might want to consider as a group is to do like 3 of these short presentations, a little bit of time for questions and answer, and then perhaps a short section at the end where people can discuss pending, let's call it pending legislation or cases to watch or things that might be coming up. These presentations tend to be about things that have happened or changes in the law. It might be interesting to hear what's happening or what is being expected to happen in the short term in various jurisdictions that might catch people's interest and that they want to keep an eye on. Just to mix it up a little.
Thanks, Alan. Do we have more hands raised, Hannah?
I do not see any.
No. Well, then we've been taking notes on all of this, and I think we will, Fibke, for example, we will be seeing more of the bundled formats or well, more topic directed formats like this in the future. For this one, we actually decided not to get a variety, but there will be such also. I agree with your statement that if you bundle a number of presentations on one particular topic, the participants can select whether or not this is an interesting session for them or not. But we will try to have a mix going forward. With that, thank you, Hannah, and thank you to all the speakers for today. And we've run over with a couple of minutes.